A very warm and a hearty welcome to each and every one of you. A very warm and a hearty welcome to each and every one of you watching me live on this YouTube channel. So friends, today we are back with another very important session on mock analysis. All that we are going to do today is simply to analyze this particular mock. Okay, now what is this mock that was held between 29th of May and 31st of May? We are going to analyze that in detail. Okay, so let's get started. Okay, let's get started with this particular mock. So the legal reasoning questions were 40 legal reasoning questions were given today in this particular mock, and total of 150 questions, right? Now, the legal reasoning, the pattern of CLAT 2022 was 8 passages. So we had 8 passages. We have to solve 8 passages having 5 questions each. So we have 40 questions to solve. Now, the legal reasoning passages came from section 378, misappropriation of property, section 17 of the Indian Contract Act, section 2A of the Indian Contract Act. Then we had the Kedarnath verdict relating to sedition, then the Hindu code bills and law of nuisance and adultery. So these were the 8 topics that were precisely asked in this particular session. Now, this is the score, the name of the student. Okay, just a second. So this was the precise score of the students in this particular mock. So I'm sure that you can see your names who have ranked 1, 2, 3, 4, 7, 8, 9 and 10. Okay, these are the scores. Congratulations to those people. So the first question, okay, it relates to adultery. Okay, section 497 of the Indian Penal Code. Then you had the judgment relating to Joseph Shine versus Union of India. What was upheld, what was criminalized, you all know it. Okay, so this particular judgment overruled a judgment which upheld criminalization of adultery, right? So this was a very important passage, and I'm sure that since it's a mock analysis, most of you have read this particular passage in detail while you gave that mock test, right? So we move on to the next slide. Okay, so here we see a very important passage relating to a very important judgment of a historic nature. Okay, criminalization of adultery. It was held unconstitutional. So a particular section which held that adultery is okay, it's criminal offense, it was held to be not a criminal act. Okay, very important. Okay, so this was this particular passage. I'm sure that you guys all have given sat for that mock test, so you know the passage. Okay, it's just a glance through. Okay, fantastic. So the first question, adultery was an offense against what? Society, state, individual, all of the above. And the correct answer is option C. It's a crime that is committed against the society. Because a penal law of crimes, deals with crime or an offense against the society at large. The next question. If adultery is committed by the consent of both male and female, only the male is liable, only the female is liable, both A and B, or none of the above. And the correct answer is option A. It is only punishable against the man. Okay, only the man is punished, not the woman. The next question. The contention for decriminalization of the section, was it arbitrary, what is anarchic, or is violative of the right to privacy, or all of the above? And the correct answer is yes, all of the above. It violates your right to privacy, it is archaic, it is unconstitutional, it is invalid, and it is opposed to the autonomy of a woman. Okay. The next question was, in this particular mock test, the object behind decriminalization of section 357 was to discourage adultery, promote gender neutrality, modernization, or both B and C. And the correct answer is option B. Adultery provides that a man to be punished in case of adultery, but no action against the woman. Hence, it was made gender neutral. It was made gender neutral. So the term is very important. So women should be treated at par with men as the object of adultery was too bad. Okay, is that clear? The next question, 115. On reading of the passage, it can be inferred that adultery is now onwards what is a criminal offense, ground for divorce, no offense, both B and C. The correct answer is D. That is, adultery is considered as a civil wrong and the remedy is divorce. The husband can go for a divorce. Is that clear? All of you? Did you all understand? Did you all understand this particular set of questions? Okay. Moving on to the next passage. Okay. It deals with nuisance. What is nuisance? What is the definition of nuisance? Everything has been categorically mentioned, right? Everything has been categorically mentioned for you. Okay. What are the essentials of public nuisance, private nuisance, the kind of nuisances? Everything was given to you in this particular mock test, in this passage. Okay. The first question, 116. Nuisance and trespass are anomalous and equivalent. True, false, can't be inferred, none of the above. And the correct answer is it is false. Nuisance is anything that hurts or causes annoyance. And trespass is entering into someone's land without the permission of the owner. So these are two different concepts altogether. The next question. A is preparing for IS. There is a continuous noise in the industrial area by mill machines for 1 month, causing disturbance to A. Can he sue for nuisance? And the correct answer is option B. Essential elements of nuisance includes a wrongful act. So A, now please understand this. It is in an industrial area. Now there is a difference between residential area and an industrial area. In residential area where we live, it can be silent, but in an industrial area, if you are living, that means you have given a consent to be disturbed by those noises. Okay, so A cannot sue because it is an industrial area. The next question, question number 18, A is preparing for IS. There is a continuing noise of a drill machine for 1 month in the residential area. Now this is a residential area. He is affected. Can he sue for nuisance? And the correct answer is yes, he can sue because it is a residential area and not an industrial area. Very important. It is a residential area, not an industrial area. Okay. 19. Okay. Is preparing for IS. There is a continuing noise in the residential area by drill machine for a month. A is affected more than anyone else in the locality. Is it a public nuisance, private nuisance, both A and B, or no nuisance at all? The correct answer is it is causing disturbance not only to Mr. A but to a lot of people. Okay, the society, the entire people who are living in the colony, in the society, are affected. Their rights are affected. Okay, the members of the society. So it will constitute a public nuisance. Am I clear? Is that clear to all of you? The next question. Does a wrongful act without damage or injury to other amounts to nuisance? And the correct answer is no. Okay. What are the elements? Wrongful act. Any act which is done with the intention to cause any infringement of a legal right to another is called a wrongful act or damage, which the law should be considered as a substantial material for the claim. So the correct answer is B. The next passage is related to Hindu adoption and maintenance law. Okay, the Hindu law. Please read the passage. I'm sure that you have already read the passage while you gave this particular mock test. So I'm sure that you know everything. Great to see that. If you're liking today's session, do press the like button, and thanks from my side for liking it. Okay, the Hindu law relating to maintenance and adoption, okay, is provided. Okay, very important. If a female wants to adopt a girl child, what is the correct answer? The correct answer is option B. If the adoption is to be taken by a female and the person to be adopted is a male, then the mother should be 21 years older. Thus, the condition does not apply to female and female child only by a male child. Is that clear? A mother. 2. The next question, 122. A couple always wanted to adopt a child. A adopted a child without consulting his wife at the time of adoption, considering that she will agree in all causes. However, on adoption, A's wife refused to identify adoption. Is the adoption valid, invalid, partially valid, cannot be inferred? The correct answer is it is not valid. both the mother and the father has to give her consent. Both the wife also has to give the consent during adoptions. Okay, that is very, very important. Can a person adopt a child of 17 years of age? Is it yes, no? The correct answer is what? Only on existence of custom. Only if there is an existing custom, or else 21 years. Minimum 18 years has to be. Unless and until there is a custom. For a valid adoption, it has to be not completed the age of 15 years. Now 18 years, 19 years, only if there is a valid custom. Only. 124. A was validly adopted from family X. When he grew up, he found that he belonged to family X and his birth parents want A back. Is it possible? Correct answer is no, it is not possible. If it is a valid adoption, he is already adopted by someone else. So readoption is prohibited. Readoption by the birth parents is prohibited under the law. 125. Can a Muslim after conversion to a Hindu faith adopt under the Hindu Adoption Act? The correct answer is yes. A Hindu may be converted or a reconverted, that is not implemented. Adoption must be a Hindu. That is it. The act applies to Hindus only. So the correct answer is option A. Is that clear? Is that clear to everyone? Okay, fantastic. Okay. Moving on to the next passage. Okay, this is relating to sedition and the Kedarnath judgment. Okay. Okay. The question: what is the contingence of the government to protect the impugned law? And the correct answer is D. The note by the government said that the Kedarnath verdict is a good law. The government said that Kedarnath judgment upholding sedition law is a good law. And the ratio and the logic has been tested and applied in various cases. Very recently in the Vinod Dua case, where the journalist was booked under the sedition law. Okay. The constitutionality of the impugned law is stated under which law? Which judgment? Correct answer is option C. Cites Kedarnath verdict that allowed sedition to continue as a part of the Indian Penal Code, which was upheld in Vinod Dua's case. Thus, the correct answer is C. The law relating to sedition is challenged on the ground of what? Is it violative of fundamental right to protest? Both. The correct answer is both. It is used to curb fundamental right of life, dignity, personal liberty and freedom, and to protest and dissent. Okay, so it's been used very easily by the government, by the state, to take away the freedom, take away the dignity, liberty of people. 129. What will happen to the pending cases relating to sedition till the law is in abeyance? And the correct answer is, the above cannot be inferred from the passage. This particular thing has not been stated in the passage or in the judgment. What will be the inference of this particular judgment in pending trials, in pending cases? 130. The Government of India contended reconsideration of constitutionality of sedition law. Is it true, false, cannot be inferred, partially true? And the correct answer is it is false, because the government is saying that the Kedarnath judgment is a good judgment. It has been followed all throughout. So there is no point relooking or reconsidering the Kedarnath judgment. Am I clear? So the correct answer is option B. Okay. Great. Moving ahead. The next passage, please read the passage very carefully. This deals with Indian Contract Act, offer, acceptance, invitation to an offer, intention of the parties, what is an agreement, what is a contract. Everything has been categorically stated in this particular passage. Okay, please read the passage very carefully. Read the passage carefully. Please read the passage very carefully. You will understand what is stated in the passage. Deals with the Indian Contract Act. Okay. 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 First question. Seema ordered spring rolls in a restaurant which is duly enlisted in its menu. The waiter told Seema that spring rolls are only available in the evening. Can he sue? The answer is, display of menu is an invitation to an offer or an invitation to treat. It is not an offer in the first place. Okay, so the correct answer is option D. An advertisement to refund money and compensation if the person catches influenza. Is it a general offer, specific offer, no offer, or invitation to an offer? And the correct answer is it is an offer that is made to public at large. So it is a general offer. It is a general offer. Am I clear? Very good. Most of you got it right. And I was going through the mock test results. Most of you got this right. 133. Ojas and Mohit decided to watch IPL match at the stadium. Ojas purchased 2 tickets, but later Mohit refused to go to the movie hall for the IPL match. Now, is it a breach of contract? Now, there is something called social contracts, which are not where there is no intention to enter into a contract. Okay, these are contracts where there is no intention to enter into a contract. So the correct answer is option B. They have no intention to enter into a legally binding agreement. Okay, that's the precise answer. Okay. 134. Priyanshi sees a dress of 1,000 rupees on display and went inside the shop. She tried to dress and adored it perfectly fitting. She paid rupees 950. The shopkeeper refused to sell it the dress at less than 1,000. She again offered 1,000. And the shopkeeper refused. Now, the second time she is making the offer. Keep that in your mind. So the correct answer is option C. Display of clothes, it's an invitation to an offer. An offer was made by the customer to sell the goods, which can only be accepted by the seller. So the correct answer happens to be option C. This question, I saw a lot of people giving me the wrong answer. Okay, but whatever, good. 135. When one person signifies his willingness to do or abstain from doing something with a view to obtain the assent of another, it is called an offer, proposal, invitation to offer, or both. And the correct answer is option D. It is called proposal or an offer. It is called an proposal or an offer. Okay. The next passage deals with fraud relating to the Indian Contract Act. Fraud, misrepresentation, both. Please read. Okay. Okay. One 136. Shyam seeks to sell his property in Rampur to Ram. Ram paid the earnest money to Shyam in furtherance of the contract of sale of the property. After receiving the earnest money, Shyam discovers that the property belongs to his brother and refuses to sell the property to Ram. So, insofar as the leading case of Derek versus others versus Peak is concerned, decide. And the correct answer is yes. Knowingly, without belief of its truth, recklessness, careless, without to be true or false. So, yes, the correct answer is yes. Number 2, as per the passage, which of the following is not an essential ingredient of fraud? The correct answer is bona fide. Okay, bona fide is not an important ingredient of fraud. Very important. 138. Aman seeks to sell painting of a famous painter to Bipin at a very low price, which Aman did not know to be an imitation. Here Bipin also did not know that the painting was an imitation and purchased it. Later Bipin discovers that the painting was not the creation of the famous painter. Can he sue? The correct answer is no. It's a fraud arises out of deliberate active role. Now over here, the man who is selling, he did not had the intention to deceive. He himself did not knew that it was not the original thing. The person who was selling the photo did not himself knew that it was not the original thing, that it was a duplicate copy, imitation. 139. Same question, similar question. Okay, that's the only difference. The correct answer is it is void, voidable, not voidable, and the correct answer is fraud or misrepresentation which did not cause the consent of a contract of a party practiced. Fraud is defined as an intentional perseverance of the truth if you rely upon it. Thus, Bipin purchased the painting knowing that the painting is an imitation. It cannot be said that the contract was concluded due to fraud, and thus the contract is not voidable. Very important. It is not voidable. Is that clear? 140. Okay. To this question, the correct answer is option C. So, thus, where there is no deception, the contract is valid. No deception, the contract is valid. Am I clear? Are you understanding how to solve these questions? Now, these questions are not very difficult questions, beta. These questions are, you have to know the concept very clearly. If your concepts are absolutely clear, then it is not difficult. Okay. So, these are the explanation which gives you the reason why a particular question has a particular answer. The next set of passage. This deals with criminal misappropriation of property. Indian Penal Code. Yeah. Okay. Okay. 141, a person takes property out of the possession of another. Has he committed what? Criminal breach of trust, criminal breach of property, which of the following? Correct answer is D. However, under criminal breach of trust, criminal misappropriation of property, the property comes to the offender. Yes, he does not take that property out of the possession by his own consent. That's the difference. There's a understand it. This is a case of theft. Criminal misappropriation of criminal breach of trust, criminal misappropriation of property is where there is a fiduciary relationship with it, but someone takes the property, it amounts to theft. If a person converts the property to the use of his friend, he is liable for criminal misappropriation of property, and the correct answer is yes, it is criminal misappropriation of property. What is the core difference between criminal misappropriation of property and criminal breach of trust? Dishonest intention, movable property, entrustment of property, all of the above, and the correct answer is entrustment of the property. Entrustment, you have a fiduciary relationship insofar as criminal misappropriation of property, criminal breach of trust is concerned, but not in others. That's very, very important. You must keep this in your mind. 144, a person finds a ring on the road and keeps the ring not knowing who the owner is. Has he committed an offense? Which of the following? He has committed. Who has found the ring did not convert the property to his own use, which is an ingredient of the section. So the correct answer is it is not an offense. If a finder of a good, if you see a gold coin somewhere lying down in the street, you pick it up. Have you committed theft? No. 145. Can the offense of criminal misappropriation of property be committed in good faith? The correct answer is no. The correct answer is no. Dishonest intention is an essential for this offense. So, in criminal law, mens rea plays a very important and a crucial role. Mens rea plays an important and a crucial role. Keep that in your mind. Whenever we are discussing about criminal law, this thing must be there on your mind. Okay, guys, fantastic. Great. Great to see that. The next passage. Again with criminal law, Indian Penal Code, theft. Okay. Presence of which of the following will condone the offense of theft? Ownership, consent, both A and B, none of the above. And the correct answer is B. Consent of the person from whom the property is taken. If he says it's not a theft. Very simple question. It was a very damn easy question. 147, it can be inferred from the above passage that theft is a genus or an extortion in species. Is it correct? Not correct. The Correct answer is no. Offense of extortion is more like cheating and then like theft, since cheating is also capable of being committed in respect of an immovable property, but they both differ. Is that clear? They are not the same thing, they differ. The next question is 148. If property is obtained by wrongful consent of another, it is extortion, theft, A and B. Depends on the facts. The correct answer is, in the case of extortion, there is a delivery of property which is wrongfully obtained by inducing fear. So extortion, there is an inducement of fear for extracting the property. It is not theft. There's a little difference between the two. 149. Theft is an offense against ownership. True, false, depends on the facts and circumstances. None of the above, and the correct answer is false. Theft is an offense against possession and not ownership. You can steal your own goods even if you are the owner. Okay, if a person is the owner of a thing, then he can also commit theft of his own property. That's very, very important. Now, these are the real type of questions which do come in your entrance examination. So when you are looking at a particular passage, you must have the understanding of how to solve these passages. That is very, very important, guys. Your concepts of law must be very, very clear. Now, people at times, what they fall is that their concepts are not very clear and they attempt the questions. No, unless and until your concepts are clear, it will be difficult for you to solve these passage based questions, which is an important thing. Am I clear to each and every one? Okay, great. Moving on. The next question. Theft can be committed of movable and immovable property if the intention of the doer is dishonest. Movable and immovable property, or is it only for movable property? Only movable objects you can steal my specs, my pen, my shirt, my laptop, but you cannot steal my house. You cannot steal Taj Mahal for that matter, right? So how was it? How was this particular thing? Tell me that. How was this particular? Okay. 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 So I'm sure that you guys enjoyed today's session. You guys understood it. Thank you very much. Thanks for watching. Do like the session. Do share this session. So thank you. God bless you. Stay home, stay safe, stay healthy. Have a great evening ahead. Bye-bye. Take care. Thank you.